Good afternoon. I'd kindly request us to move. Those at the back of the hall, kindly move. Tupendane tafadhali. In Kenya tunapendana, so kindly move forward. Do the preliminary. Good afternoon again. I'd like to welcome you to today's book launch. We will have a book launch and we'll also have some expert speakers. Welcome to the Kenya School of Law. You're in the premise of the Kenya School of Law. For our guests, you're most welcome. For our students, feel at home. This is your home. Without much ado, I'd like to request our Reverend Joseph to kindly come and start us with a word of prayer. Reverend Joseph Mutungi is the Bishop, Anglican Church, Diocese of Machakos. Karibu.
Good afternoon. Thank you for the invitation. I was also made to make few remarks just before we pray, although we might be a little bit late, but what we are doing today, brothers and sisters, is so crucial to us. The centrality of God in human pursuit and acquisition of knowledge is critical for us. And I want to appreciate my fellow brothers who have been invited as speakers. And I want us to be guided by the book of Ecclesiastes 12:9-14. The right judgment in life starts with understanding your own purpose of existence based on the reality and the truth of life. And certainly, man does not seem to be short of this ability to think and to make decisions. Our ability to study, to understand, and invent seems to be, by any means, no limit. As we dig deeper in search of knowledge, and our intuitional power reveals great insights which inform our minds and the brains to respond in problem solving, to reduce human suffering, and to bring peace through reconciliatory approach. The dilemma and with our problems and the issues remain if every knowledge generated by the millions of world scholars like we are gathered today here, and it's properly applied, then the question remains, why do we have world of good without evil? Why don't we have a world that is peaceful, harmonious, and the things are moving on? The problem that we have, brothers and sisters, is not lack of knowledge, but our biggest problem lies in using our knowledge and inventions. Most of the time where we destroy ourselves and human life, instead of directing the acquired knowledge to improve and make our lives better. I believe our failure to use knowledge for constructive and betterment of life is the reason as to why courts of law exist to solve human disputes, because of our misunderstandings. A man by the name Tolstoy describes life as a stupid joke. He thought it was pointless to continue facing challenges of life and the efforts to overcome them, and eventually simply die, just die, after so many struggles. And as a result, he decided to commit suicide to end this meaningless life. Luckily, Leo was rescued by colleagues, and afterwards he acquired new direction and the thought about life and the purpose for his living. He rediscovered a new faith and the force behind his life, and that was faith in God. Scholars of all disciplines, philosophers, scientists, anthropologists, all try to provide answers to the human suffering in pursuit to bring peace and universal harmony for human order. This is because man has a sense of moral obligation of what is good and the evil. And the one by the name C.S. Lewis observed that men have a sense of moral obligation which they feel as a claim coming from outside themselves. As the man's search for God's existence, and the million-dollar question then still remains, does God exist? And if he exists, why endless evil and human suffering? Why money problem and even financial institution misunderstandings that is causing Brother Matthew Okoth sleepless nights to write 600-page book on corporate finance? And this is mitigation. Why don't we have just, Brother Matthew, operate on the natural law and allow things to flow amicably? So somebody observes that the existence of evil is that man in the world is not to find a carefree, happy existence, but to continue soul searching to achieve full development through experience and a learning to overcome problems that exist in this world. Religious experience and knowledge, therefore, comes into play and necessary in solving the human suffering and the challenges in pursuit of human peace and harmonious living. Faith is usually always belief unsupported by evidence. Faith is as a result of man's discovery of depravity. Human mind, given all its ability to think and invent, can only go as far as discovering the mind of God, the creator of the universe. And that, I want to share with you a testimony by a man, Chris Morrison, who lived between 1984 and 1951, astronomer and the president of the New York Academy of Sciences. And he gave reasons as to why we should believe in God and understand him as the source and the author of our knowledge. And out of the 7, I just want to share, by unswerving mathematical law, we can prove that one universe was designed and executed by a great engineering intelligence. And the other one is that the fact that men can conceive the idea of God is not itself only unique, but special revelation by a supreme authority. The conception of God arises from divine faculty of man and shared with the rest of the world. And this faculty is called imagination. By its power, man, and the man alone, can find the evidence of things unseen. And this becomes a spiritual reality. Man can discern all evidences of design and the purpose, the great truth, that heaven is wherever and whatever, that God is everywhere and in everything, but nowhere so close as in our hearts. It is therefore scientifically as well as imaginatively true, as the psalmist in Psalm 19, verse 1 and the following. And allow me, I just read the few lines to guide us. That the heavens declare the glory of God, the sky proclaim the work of his hands. The law of the Lord is perfect, reviving the soul. The statutes of the Lord are trustworthy, making wise the simple. May he give us the desire of your heart. May he give you the desire of your heart and make all your plans succeed. Who can discern his errors? Forgive my hidden faults. Keep your servant also from willful sins. May they not rule over me. Then will I be blameless, innocent of great transgression. And in conclusion, brothers and sisters, the denial of God's existence subjects us into human reason alone, which itself is limited into our moral obligation. Secondly, our faith in God connects us to the mind of God, the author and the finisher of our lives. God is the source of all knowledge and the truth and the reality of life. Third, the Bible is the imagination of who God is and points to God's order of man's relationship to his creation and to himself. Other books, Ecclesiastes, chapter 12 from verse 13, will be written, including this one, and have been written from one generation to another to provide knowledge and wisdom. But I want to say the word of God will remain unchanged. God himself is the source of knowledge. And by writing such a book, which our brother Okoth has written, is an inspiration that we are co-servants of God in his kingdom. And I want to believe that as we provide this information, is God's inspiration, that we continue to provide the knowledge. But let us also appreciate that we are limited in one way or another. It's only God who can bring solution and even make harmonious living as we continue to relate with him, that he can enable us to relate with one another. May God bless you. Kindly, shall we stand to pray? Our Father and our God, we want to thank you for this great moment and opportunity you've given us, and that we'll be able to gather here, that we may listen, we may learn. We thank you that, God, you have created us in your own image, and in your own likeness you have made us. We pray that, God, as we share this knowledge, we share your love, as we start this ceremony of celebrating of our brother, the work that he has done, the resources he has spent, we pray that, God, you may put in us even to realize who you are and how we can be co-workers with you. For this we pray in Jesus' name. God bless you.
Thank you, Reverend, for that prayer, and more importantly, for the spiritual nourishment. I'd just like to take this opportunity to recognize a few important guests. Mr. President, Law Society of Kenya, you're most welcome. Mr. Mohamed Nyaoga, Chairman, Central Bank of Kenya, you are most welcome. Madam Anna Konuche, that is one of us here. She'll be speaking to you later. All those you'll be hearing from them, so I'll not go into that right now. You'll be hearing more from them as we go along the program. I'm going to request Anna Konuche, we are in your neighborhood, we're in your hood, so please come along and give welcoming remarks.
Thank you, Deborah. You know, I heard you telling people to pendane. They should sit so close to each other. And then the Reverend came and I said it's an opportunity to thank God, because 2 years ago, in this same hall, would be asking people to move away from each other because of COVID. But now we are asking them to sit together. So it's an opportunity to thank God for the far he has brought us. The chief guest, Mr. Nyaoga, the president of the Law Society of Kenya, Mr. Eric Theuri, the vice president of the Law Society of Kenya, Mr. Faith Odhiambo, other distinguished guests, ladies and gentlemen, good afternoon. Yes, when Matthews approached me after I saw his post on Facebook, and I told him to launch this great book. Our book launches in town or out of town, but we've never really had this opportunity the book covers is a lot on commercial transactions. It has a lot of question and answers, answers with regard to what they are taught. The nature of ATP is that you cannot pick one book and say, go and refer to this book for this subject. Everything is scattered all over. To that specific unit that is covered at the school. So we are excited as a school and also to partner with Matthews, the author, and also even guests who've come here to school, maybe it's your first time in a long time. We are excited to partner with you. As a school, we have opportunities for advocates in the field or even other areas who want to come and mentor our students. We have a mentorship program, you're welcome. We do offer guest lectures, you're welcome to also speak to them occasionally on guest lectures. So we are excited to have an opportunity where we can partner. So if you feel you're able to approach us, then you're welcome. So finally, on behalf of the school, think and
And you want to we have that important that has in his career and who's able to offer this important is mentorship. And mentorship is a very important thing. I'm sure as young upcoming lawyers, you know, your assistant director has mentioned that you do have mentorship programs, but it's important to also emphasize that mentorship goes along your entire career. I'll put the chairman of the central bank on the spot at some point because we have pending, he was my mentor at some point, and we have pending meetings. So mentorship is ongoing. So I am still being mentored, and it is an ongoing process. So I'll just invite Geoffrey Imende. Briefly, I'll just read out who Geoffrey Imende is so that you know who he is. Geoffrey Imende, aside from being a partner at Mohammed Muigai Advocates, was my schoolmate. I don't know if he remembers that. He does remember. He's a managing partner at Mohammed Muigai Advocates and an advocate of the High Court of Kenya of over 18 years standing. He's a graduate of Moi University and the University of Nairobi, where he also obtained LLB and LLM degrees. He serves as an examination moderator for the trial advocacy paper administered by the Council of Legal Education and sits as an arbitrator in construction and other commercial disputes. Kindly help me welcome Geoffrey Mende.
Thank you, Deborah. Good evening. It's evening, Mohammed. Thank you for the invitation to Matthews and the team. I'm very honored. It's a joy and honor to be here this evening. A joy because Matthews Okoth, my former pupil, has written a book. I'm very proud of you, Matthews. And I'm very honored to also be here because we are celebrating new knowledge immortalized in a book. If you look at the research material that you're going to be using here at the Kenya School of Law, most of it is not locally authored. We mostly use books from the UK and other Commonwealth countries. So for a young advocate, my former pupil, to write a book on such a technical area of law is very commendable. Most of the books you will see now on Kenyan jurisprudence, laws of Kenya, are written by PhD holders, very senior and distinguished practitioners. So it is no mean feat, and it's a challenge both to myself and to the rest of us to immortalize whatever thoughts we have, whatever area we have a passion in, try and immortalize it in a document and try and grow it. It starts from there. Now, I've had a speech prepared, but because of time, I did not intend to go through the entire speech. I just wanted to make some observations about mentorship. I was Matthew's mentor from pupillage when he came as a very young, innocent boy for pupillage interview. I remember he was very shy, and he's an introvert. But during the interview, we could see the striking knowledge that he has. He's very well informed and can deliver. So of course he distinguished himself during the interviews, and we took him in as a pupil. He finished his pupillage and was an advocate. But at some point he came to me and told me, "Sir, I found an opportunity elsewhere. I need to see whether the corporate world is my area." And so he moved to Mastermind Tobacco. He invited me after a couple of years for his wedding. I remember going to somewhere in Syokimau to give a brief speech when he was getting married. And I'm happy to see that Agnes is still in your life. Agnes, I don't know if you remember me from the wedding in Syokimau. And you'll see from the banner, AML Publishers. It should not surprise you that it's Agnes and Matthews Publishers. I'm making an assumption on your behalf. Anyway, back to mentorship. I wasn't formally mentored when I was in my formative years. I didn't have a formal mentor, but I drew some inspiration from my mother. My mother was widowed when she was in her early 30s. I was 10, and we were a family of 4. So through her hard work, earning a salary of 10,000 shillings, she took us through primary school, high school, university, through borrowing loans, SACCO loans, and that's how she paid our fees. We would have struggles putting food on the table. There's a day, I remember we had a family meeting to discuss how 100 shillings would take us through the week before her next paycheck came. So from her own hard work, her sheer resilience and focus, I grew up learning a few tips from her. When I finished university, I was privileged to join the law firm of Mohammed Muigai Advocates. And I didn't know anyone. I just went through an interview and I joined the firm. But at Mohammed Muigai LLP, I was privileged to find mentors there. And one of my mentors is with us today, the keynote speaker, Senior Counsel Mohammed Nyauga. He's mentored me for the last 20 years. And I'm very thankful, sir, for your mentorship. We all need mentors. Mentors hold your hand. They guide you. They answer the questions that are really disturbing you in terms of your career path. All look for a mentor. We should all look for a mentor to help you chart the path. If you don't have somebody who you look up to, you can find a mentor. The Reverend Bishop Mutungi told us, we must know our purpose for life. You need to look at your career path and make a choice. Introspect and decide which is the career I want to be in, which is the highest form of achievement that I want to attain. Once you identify, I want to be a judge, I want to be a professor, I want to be a lecturer, look around your circles, professional circles, or even if you don't have somebody in your circles who has attained that, look around. Who has attained, who do you look up to? Who would you look up to and say, that is where I would want to be? Now you have to, of course, go out there and try and talk to them to be your mentors, and you'll be surprised. Most of us are very readily available to be mentors. I was here last year with Madam Konuche doing a mentorship program in November, and right now I think I have 5 mentees from that program, last year's program. So we normally have an innate fear to go out and approach it. We assume that mentors are not willing to mentor. I received complaints the last time I was moderating the bar exam from one of the lecturers saying, but you seniors don't want to mentor. It must be yourself. You must push yourself, take yourself out there and ask. It shouldn't be for the senior to look for you and ask you, do you want to be mentored? You must go out there and say, are you available to be my mentor? You'll be surprised that most of us are readily available to mentor. So let it be a challenge to each one of us. Look for a mentor, and he'll help you, guide you, and just challenge you to go to reach the levels that you ought to achieve. Now, even before you get a mentor, or as you go through the process of getting a mentor, you can still be mentored indirectly. And you can be mentored by the biggest people there are, Bill Gates, Oprah Winfrey, whoever it is you want, because they write books. They have podcasts. Today, technology allows us to access all this information. So as you chart your way forward, read books, look up books by all of these people you look up to. They have books, read those books. They will give you an idea about how to get to where you'd want to be. In closing, and I go back to the man of the moment, Mr. Matthew Okoth. I'm told that there are 3 things we need to succeed in life, and that's a good doctor, a good lawyer, and a good accountant. Matthews, you've ticked 2 boxes, a lawyer and an accountant. I'm sure what is remaining for you is being a doctor, and knowing you, I'm sure you're going to achieve that very soon, PhD. So challenge right there. But in all seriousness, I would like to congratulate you, Matthews, for this huge achievement. It's a true testament that hard work, determination, and commitment to excellence pays. I'll quote Aristotle, who said, "The roots of education are bitter, but the fruit is sweet." Matthews, your journey has been a testament to this truth. And I'm sure that the fruit of your labor will be very sweet. And to all of us, I say this, take up the challenge and be the best version of yourselves. Every day, Strive to be better than yesterday. Beat yourself every day, and you will do well. Thank you.
Thank you, Geoffrey Mende, for those very wise words. The man of the moment. I see him adjusting his coat. As he walks up to the podium, he has a very impressive profile. However, I'm going to summarize it. And Matthew, as you take up the podium, please remind Imende that once you get a wife, you are no longer certified as shy. So you should stop telling that story. So Matthew, very briefly, is an advocate of the High Court. He has been in practice for 12 years, and he specialized in corporate law and public finance litigation. He's an alumni of Moore University, as many of us in the room are. President Eric Theory, I see you nod your head. He has a master's in law from University College London, UK, in corporate finance. He has a certificate in finance economics from Edinburgh Business School. He's pursuing his second master's in public finance at the University of Nairobi. He undertook his pupillage at Mohammed Mugai Advocates, where he met his mentors. And then he proceeded to the corporate world, where he was a group senior counsel at Mastermind Group. He then proceeded to the firm of Tom Ogenda and Associates, where he was an associate. And now he runs his firm, Agnes and Matthews Law LLP. You have met Agnes, so you need not look for who the partner in the firm is. Without much ado, I'd like to welcome Matthews Okoth. Help me give him a round of applause.
Thank you, Deborah. To Senior Counsel Mohammed Nyaoga, to our Lord Bishop present, to our President, Law Society of Kenya, my friend and mentor, Mr. Imende, Malimu Konuche, Deborah, and distinguished ladies and gentlemen, good afternoon. In fact, it's a great honor to have you converge in this place to join me in celebrating this achievement that I've held for so long. Senior Counsel, there are giants that over the years have enabled me to lean on their shoulders to be who I am today. And with your permission, I will take a few minutes just to acknowledge them. Firstly, I want to acknowledge God for the sustenance and the life and the resilience that He has given me over the years. And I thank you, Lord Bishop, for finding time to join us this evening so that together we can recognize that all this is never so much about us, but Himself glorifying Himself through our works. I thank the firm of Mohammed Mugai Advocates. If there is one firm that I've always leaned on over the years, and every time I step into that firm, they've always been all out to render support, is that firm. I thank you so much, Senior Counsel, for the candle you lit on my path. I thank you, my friend Geoffrey. You have been really true friends and partners in this journey of law. I thank you, Malimu Konuche, from the time that I called you to just mention to you that I desire that I launch this book here. I have seen in you a teacher and a big sister. I even got airtime from Kenya School of Law. So thank you so much for your friendship, for the support, everything that I needed, it was sorted. Thank you, my president and my vice president. I've known Eric for a while now, and he's a very easy person. When I mentioned to him, the way we conversed about the issue, it was so social. And thank you so much for always opening your doors for me. Thank you, my friend Faith. Thank you so much, my friend Ataka, who is in the house. One of the persons that I have partnered with over the years is Ataka. and he has been like a brother to me. And just before I conclude, writing is a very lonely process, and you need a very strong partner in the journey. I recognize you and thank you, my wife Agnes, for the support over the years. You and our children, Jay and A, you have been my greatest cheerleaders in this journey. I thank you so much. Distinguished ladies and gentlemen, thank you and welcome to the book launch. And now with your permission, Senior Counsel, I will proceed to the launch. Now, this book on the law of corporate finance attempts a legal inquiry on the laws that govern the way in which we raise finance. And once we raise that finance, what can we really do with the finance that companies raise? So that is actually the entire journey that this book attempts to achieve. How do companies raise finance? And the moment after raising that finance, what are some of the constraints on companies on what they can do with the money that they raise? And in order to understand that, we need to first appreciate, why do companies really need finance, right? Finance is like the fuel that the companies burn. It is what they use for their operations, for their working capital, for payment of salaries and overheads. So it is a very critical part of, their operations. Now, how do they raise the money? They raise the money in a number of ways. I'll first just broadly mention them before we get into some detail about them. One of the ways in which companies raise finance is through what we call debt financing. And debts are just loans and corporate debt securities. We all know loans, corporate debt securities. If companies are trading on a stock exchange, they can list their shares on a stock exchange or offer bonds or notes, or what we call commercial papers, and then they raise money on the exchange. So debt is another form in which companies raise finance. Then internally, at times companies make profit, but they do not consume all that profit. They're what we call the retained earnings, right? Now, the retained earnings is another form through which companies raise finance. Then there's what we call mezzanine finance. Mezzanine, if you know a mezzanine floor in any building, between the ground floor and perhaps the first floor, there's a space we call mezzanine, which is never so much used for anything. But in terms of company operation, this form of finance is very key and critical. It's mezzanine in the sense that it has both, it's in the middle of debt and equity. So it has characteristics of both debt and both equity. And I have tried to highlight a few, just by way of summary, before we get into detail. What we call preference shares, shares that have fixed and cumulative returns. In the Articles of Association, there is a stipulation on how much dividends will the holder of these particular shares be paid. Convertible bonds start as debt instruments. Then at some point they convert into shares, right? They are what we call warrants, junk bonds. These are low-ranking debt instruments in a company operation. We'll get into the details of that. Now, not all companies have the capacity to raise money through the key forms. And the key forms here mean debt, equity, retained earnings, or mezzanine finance. And that's why if you have a startup, an SME, a small company that just wants to raise money, they can have a line of credit where they're allowed to spend money that they don't have. Then for their working operations, once they raise the money, they then pay for that credit. So credit card is a form of financing. For those who are in business, at times you may get supply from, say you are in manufacturing. You can get a supply of raw material on credit, on invoice, and then you are given a timeline of, say, 30 days to pay. That timeline of 30 days, before you pay the money, you are actually being financed, because the alternative would be that you approach a bank so that you get a loan. So invoice finance is another form of financing. It is a type of financing that enables buyers of goods and services to obtain goods on credit pending payment. And in that intervening period between the acquisition of the good and the payment, you have been invoice financed. Now, if you flip that and see now whoever is supplying you, the supply of the goods to you, if it is still manufacturing, someone supplying you with tobacco, right? Now, the farmer there supplying you with tobacco has what is called account receivables, which they can assign to somebody to get money, to banks. They can assign that right to be financed by the bank upfront, then the right to be paid then transfers to the bank. So that's another form of financing. As lawyers, we lease buildings. Leasing is a form of financing. There's no outright purchase, you pay rent. And then lease back, if the owner of the building enters into an agreement with you that, fine, I have leased for you the building, but if I want to use the building, you can allow me to use the building, right? Of course, is now the owner of the building paying you rent. That is called a leaseback financing. Then we have repo, and there are many, including hire purchase. The point is, the book has covered all these in summary form in chapters 1 and 2, which are the main forms of corporate financing. I'm sorry, the projector is not clear enough, so I will try and, highlight. Now, one of the key ways we've said through which companies raise money is what is called equity financing. And equity financing is finance raising by issuance of shares, whose variance we'll also look at, right? So, what is really a share? When we say company is issuing a share to a party, a share is an artificial concept of a company. What it does, it grants the holder certain rights, bundle of rights. And these rights can be broadly categorized into two. There is what we call a cash flow right, the right to draw dividends, periodic payment if the company is profitable, and the control right, which is a governance right that you obtain by virtue of shareholding in a company. You can hire, you can fire directors. Now, as a shareholder, there are also other rights which are specific to your class. They are what we call preemptive rights. Like if, for instance, in future the company wants to issue more shares, you have the first right to be issued with those shares or given opportunity to buy before a third party buys the shares. So those are the bundles of rights. A share is not something you can touch or feel. But by virtue of holding that artificial concept, there are rights that you acquire as a shareholder. So what are the variants of shares in a company? The most common one is what is called ordinary shares. And the ordinary shares have the entire spectrum of the rights, control and cash flow, right? There are other variants of shares that have limited rights, like what we call the preference shares. Because already you are entitled to a return as a preference shareholder, you don't have the rights to participate in the management of the company, all right? So you suffer no risk if there is a mismanagement in the company, because your return in any event from the business, from the profits of the company are guaranteed by the virtue of the articles itself, all right? So preference shareholding fixes your return from your investment in the company. Now, we have what are called redeemable shares. Redeemable shares are shares which a company can call up at any time, all right? It can purchase them back. And this purchase can be at the instance of the company. If it happens at the instance of the company, we say the company has exercised what is called a buy option. But you also, as a holder of these shares, you have a right to force the company to buy those shares. Now, if you exercise your right as a holder of a redeemable share, we say you've exercised what is called a put option. So a redeemable, the critical point there is a type of share which a company can call back. Then there's a new emerging area of shareholding called ESOP. Now, these are employee share ownership plans, ESOP, employee share ownership plans. So that some employers incentivize their employees. They can allow the employee to participate in the upwards of the company, like if there's a profit in the business, right? But the one thing I would I would caution us on is that it's not so much always for the love of employees, right, that ESOP shares are issued. A lot of it always have to do with the control, because it has another function which is more critical to the owners of the business, to increase their stake. Employees, if you look at the people who represent employees, they're always trustees. And the trustees appointed are always actually the company managers themselves. In a number of cases which I have discussed in the book on this concept, you find that it is actually the company founders that sit at these trustees representing the rights of the employees under these ESOP plans. So it gives them additional stake so that in future there's an attempt, if in future there's an attempt to acquire the business, they have greater voting power. But what will be pronounced there is that ESOPs allow employees to participate in the upwards of the business. Now, because shares entitle their holders to certain rights, the law deliberately protects these shareholders, and the protection is at two levels. It's both at common law and also statutorily. At common law, there are two concepts under which employees' rights, class rights, are protected. If a company has, say, more than one class of shares, say class A shares and class B shares, and there is no express stipulation on a particular right in respect of one of the shares, then there is a presumption under common law that those shares are equal in all material respect. There is no express stipulation, for instance, on the dividend that a particular class of shares are entitled to. It is one of the presumptions of law, common law, that the shares are equal, so that there is no one class of share, for instance, that can claim greater control of the business than another. But where there is an express stipulation under a class of shares as to rights attaching to that class, then in respect of that specified right, there is a presumption that that right is exhaustive in respect of those shares. So the second presumption under common law is the presumption of exhaustiveness. Now, statutorily, of course, under Companies Act, there are class rights protection and various remedies. Like one of the ones I've mentioned is the preemption rights. If, for instance, shares under your class are being allotted afresh, you have the first right to buy, among other protection. I'm trying to run because I'm conscious that time is well spent. Now, Chapter 4 discusses a new concept of governance of shares called dual class shares. And this is one area that Senior Counsel I'm so strong on, because I'm aware that we may need to be very deliberate on how, for instance, we attract high net worth investors, for instance, to list on our stock exchanges. And the greatest fear, they are very good businesses that we have around, the greatest fear that they always have is the fear of loss of control of the business. The founders don't want to lose control. They want to pass on that business to their generations. Now that issue has been addressed elsewhere through what is called dual class share structures, some even triple class share structures, where the control right of the business is separated from the cash flow right. So that as some of us ordinary investors, we are allowed to participate in the skills of these founders of the business while we give them space to continue running the business to entrench their leadership. So in practice, how it happens, you find that the founders would be given, say, Class B shares, right, which have a higher voting power in proportion to Class A shares, which, for instance, proportion could be 1 to 10, right? So whenever there is a vote on governance, these company founders, they will always remain in control of the decisions. Dual class share structures, right? There are models that I have discussed in the book that have actually allowed this system, and through that, that's how we see high net worth companies like Facebook, for instance. Facebook, Google, we have Microsoft, I think even Twitter has a world-class share system. They have been able to attract those kind of businesses in their stock exchanges without the fear that the founders will lose control. So I've discussed various models, how they can be structured. There's what is called a permissive model, like the US system. There is an ambivalent model, like the UK, and there is, the prohibitive model that insists that all shares must have equal weight. Now, as I near concluding part 1 of this book, I want to discuss with us 2 sets of rules, which I capture in chapters 5, 6, 7, 8, and 9, that actually govern the capital raising and what companies can do with the money that they raise. Now, the first one is what is called capital raising rule. And what this rule actually states is that if a company promises its creditors or third parties that it will raise a particular amount of money, then the law steps in to ensure that it actually raises that money. And why is that important? Because it is on the basis of the nominal capital of a company that creditors deal. Whenever we are incorporating companies, we are always very deliberate to stipulate the nominal capital of the business, so that those who are dealing with us know that the fallback for creditors, is particularly unsecured creditors, is that nominal capital, right? So if this nominal capital is raised, then it has to be in a separate account. And there are 2 accounts that always deal with this, depending on the amount that is raised. One is what is called a share capital account. If the amount that is raised is the exact amount of money equivalent to the par value per share. But if there is a profit that the company makes in the process of raising capital, for instance, it sells to the market its existing shares and it makes a profit, that profit we call it premium. And that profit, a value above the nominal value, is supposed to be actually kept in a separate account called a share premium account. There is a third account that deals with the issue of capital fund, which is called a treasury account, and that happens when there is a share purchase. A company goes back to the market to buy shares from its existing shareholders. So these are creditors' money in the share capital account, money in the premium account, and money in the treasury account. These are part of the share capital fund of the business, which is not available for distribution. And if there is distribution out of it, we will see shortly the consequences for it. Now, a related rule is what is called the capital maintenance rule. A capital maintenance rule says that you can only make distributions out of the profit available for purpose. You cannot make distributions out of a capital fund, right? And which are these distributions? You can distribute company profits through dividends, which I think is the most common. There are details around it, which if time allowed, we would have gone through, right? But the key point is that whenever you want to distribute dividends, you have to distribute it only out of the company profit. Now, you can do what is called share buybacks. For instance, in private, closely held companies, family companies where there are constant quarrels, they can no longer operate as a family. They are fighting. And of course, third-party investors would not want to come to a war zone. The only way to break that gridlock is by enabling the company to buy its shares out there from existing shareholders. It's called a share buyback. It's a form of distribution. The key point of law here is share buybacks and dividends distribution happen only out of the profits. At times, a company may want to reduce its capital. Now, why would a company reduce its capital? If, for instance, over the years, there are, for instance, unpaid shares, they've done a call-up on the shares and no one is paying. Or there's a depletion in the assets of the business so that the shares of the company do not truly represent the assets of the business, right? So that the company be forthright with the creditors, it can actually force the existing shareholders to sell. The key distinguishing features between capital reduction and share buybacks is that capital reduction is actually a forced transaction and is at par value. There is no profit that is made out of the business. The last element of capital maintenance rule is what is called financial assistance. At times in a group of companies, let me use a different example. At times, there are transactions which involve a company financing its own acquisition. And this is common with private equity transactions, right? Where a third party that has seen the potential in a business, can saddle the company with a lot of debts, right? It borrows money from third parties. And then on the security of the target company that is actually supposed to be acquired, right? Now, that form of acquisition of the company is called financial assistance. There are limited instances which are allowed, which I capture in chapter 6, 7, 8, and 9 of the book. Now, the second part of the book deals with a very broad area of finance called debt finance. Now, debt finance exists in two forms. It can either be loans or it can be corporate debt securities. Now, we all know loans. The most common one in financing businesses is what is called overdrafts, on-demand loans for the working capital of the business. But that's not the only form. At times, there could be lending between a bank and one customer. It is called bilateral term loan. Term loan in the sense that there is a specific period for which that debt will be repaid. Related is what is called a revolving loan. A revolving loan is a term loan, meaning there's a continuing credit facility that is granted to a borrower. Is continuing, meaning the creditor can borrow, pay, say within a period of 6 months. It's different from overdraft, which is on demand. There is no stipulated period, right? But both the revolving and overdraft facilities are helpful in financing the working capital of a business, right? Now, how do we originate loans? And in this regard, specifically bilateral loans between one borrower and one lender. The formal document for origination, for negotiation, first this part is meet, is what is called a term sheet. And the point of law in a term sheet, I've come across cases that I've discussed in the book, one by a high court in Kiambu, I think, and another one by a high court in Nairobi, was the binding nature of a term sheet. The thinking of the court in those cases is that because this is not an offer, you are still negotiating, it is not binding. Good law, but the book takes a slightly different tangent. Because you may find that during negotiation, consequent to negotiation, there are certain things that are kind of resolved. And crucially, there is part performance. There is part performance. For instance, if there is a financing for, furnishing, the library for Kenya School of Law. If, for instance, there is a part supply as the final loan agreement is being executed, remember parties are still operating on the basis of a term sheet. You cannot renege on the terms at that point. And there are decisions that have relied on in chapters 10 and 11 of the book to demonstrate that as a lawyer instructed, if your client partly performs a term sheet, then they may be found liable for the obligation stipulated therein. It is not sufficient. I know most lawyers, what they do is that in this kind of document, they say it's subject to contract. The court looks at the merits and the intentions of the parties, not just the the expression on the face of the document. So if parties perform a term sheet, then it puts your client in a position where liability may be found against them. Now, other than after the term sheet, of course, is a final agreement. I'll highlight just a few things in a loan agreement. I know at times we are used to templates, but we need to draft with understanding. There are terms in a loan agreement, like the purpose of the loan, things that we always just, think they're inconsequential. They can be very consequential. When you state a purpose of the loan with a lot of specification, you actually enable the bank to, in future, follow through to see that you indeed applied these funds for the expressed purpose. If you don't, there are decisions that I've relied on, which actually state that the bank can actually acquire what is called a quist clause trust over that, the power to trace third parties that, you applied these funds to, the people you paid, if that fund is still available. The general thinking, though, is that a loan agreement is credit only, is only the seller, is only the borrower and the lender, right? But in the event that the purpose is very clear on the face of a loan agreement, then you put yourself in a situation that you have actually to apply the funds to that purpose. There's representations and warranty. Representations are statements of fact, which are yet to be expressed in the document. The moment you express that statement of fact in a document, we call it a warranty. And there are consequences if you don't, it turns out that you misrepresented that position. There are covenants, which are promises that you make under a loan agreement. Then there are events of default, assuming that, in these representations, warranties, you don't honor them, then you give the lender certain rights over you to declare what is called an event of default. And which rights will the lender have? They can, if there is an outstanding payment, they can, refuse to actually finance you. They can accelerate the loan. Accelerating means that they can call up, place a loan on demand, and demand that you immediately repay, among other things. Now, quickly, I'll move to syndicate loans. I've said a loan agreement between one lender and a borrower is called a bilateral loan. But at times, some financing are so large that the credit risk, the risk of extending it by one lender is so enormous, doesn't make business sense. So it involves, therefore, assembling of very many lenders to come together to extend the facility. That's the whole idea of loan syndication, all right? So the parties is the borrower, of course, the relationship bank that puts this syndicate together of lenders, we call it a REJA or a lead underwriter. And the lead underwriter, other than just putting the syndicate together, it actually represents the borrower in the transaction up to the point of execution. The moment the execution happens, another party called an agent bank steps in. And this agent bank is a representative of the lenders to enforce now the rights of the lenders under the loan agreement. At times, security is taken under syndicated loans. That security actually vests in a different party called a security trustee. I've explained in the book, in chapters 13 and 14, how this structure works in practice, right? So that and the rationale for having a totally independent party, because of a concept I'll discuss shortly, called a loan transfer. If there is a change, for instance, the identity of these lenders in future, the trustee remains constant. It is to the benefit of the lenders as at the time when that issue is raised. Now, a highlight of the documentation you need in loan syndication. If you are instructing, the relationship bank is instructing a lead underwriter, they issue what is called a mandate letter, and I've stipulated its terms. Then the mandate letter is what, then the lead underwriter will prepare what is called an information memorandum, so that, the lead underwriter is the relationship bank, is the one that knows his borrower. The people that are being brought into the syndicate do not know the borrower. So the document that actually sets out the details about who this borrower is, his business prospects and all that is called an information memorandum. And I've set out what it contains and the liability issues that may arise if the lender writer mislead actually the potential lenders, and of course the loan agreement. I'll quickly go to loan transfers. Now, for reasons of governance, which senior counsel has more experience on than me, lenders do not always remain on record for the entire period of the loan. Some of these loans may be for a very long time, even for 20 years, 25 years. And bank's business is lending. So it at some point transfers this loan, you know? Now, if it transfers the loan, first we need to know how does it transfer the loan, right? And if once it transfers, what actually is being transferred. So there are 5 methods of loan transfers, which the book covers in chapters 13 and 14. One of them is called novation. Novation is a contract to substitute the party so that the original lender falls away and a new party comes in, right? So you actually are able to transfer both rights and obligations. Rights meaning the right to be paid, and the obligation if the outstanding, for instance, payment you are yet to make. The new lender will take up those obligations. Now, the other method of transfer is called an assignment. Assignment transfers rights. It doesn't transfer obligation. And in law, we have 2 types of assignments. There is what we call a legal assignment and equitable. The distinguishing feature between them is that in a legal assignment, first, if it is in writing, you are assigning the whole amount and you register it. If any of these elements lack, then we talk of equitable assignment. And in terms of enforcement, now in practice, a person, the borrower, the assignee in an equitable assignment will have to enjoin the primary borrower whenever you are approached to sue in a court of law. I'm just rushing through in the interest of time, but all that is covered. Now, there is a new form of transfer called sub-participation. At times, the way the debt market has expanded, you find that there are banks that may not have access to large credit borrowers. For instance, Safaricom, let's take our local example. Not all banks may have access to an account with Safaricom, but they may want to at least, start progressively lending to Safaricom. So what would happen is that maybe a more established bank that has a relationship with Safaricom can agree to transfer the credit risk, meaning the risk of Safaricom not paying, to what is called a sub-participant. So a sub-participation transfers the credit risk. And how does it do this? It does that in 2 ways. One, through a process called a funded participation, where this small bank that is yearning to get access to the big bank funds. It actually deposits some money equivalent to what is outstanding from Safaricom to the big bank, right? And now when Safaricom pays, whatever Safaricom pays then is transferred to the participant bank, right? Now, if there is no payment, that is why it is called a credit risk transfer. The person that suffers is the sub-participant. If the other form is not by way of deposit, the other form is through transfer of the risk of future transfers, what is called a risk participation. What you actually transfer is the future drawdowns by this borrower, which may be defaulted upon. There is no actual deposit. There are details, which I don't have the time to go through, but I'd prepare to present on how you need to be very careful as a lawyer when faced with some of these transactional documents to draft. Because the way the market has developed, this small bank in the shadows may actually even be a vulture fund, right? And there are mechanics that have developed in that market that can eventually elevate this vulture fund to be a primary lender to the borrower. So if you are acting for the borrower, it's very important that there are certain safeguards I discuss in the book that guarantees that you obtain from the primary lender. For instance, as to who the loan can be transferred. The other two, MENA is called transfer by way of trust and proceeds assignment. Now the last part on part 2 of the book is on corporate debt securities and what is called securitization financing. Listed companies can raise finance by listing their negotiable instruments. And these negotiable instruments are actually defined by reference to their maturity profile. The one for 1 year is called a commercial paper. 1 year to 7 years is called a note. And 5 years, there's a bit of an overlap, to 25 years, I think that's the maximum I've seen, is called a bond. So much as out there the term bond is generic, they're actually different corporate debt instruments based by reference on the profile, the payment profile of the corporate debt securities. So in a bond issue, what is involved? We issue bonds by way of a prospectus. We call it information memorandum. And that information memorandum will stipulate actually, the details about the issue and of course the risks that are involved, right? Now, quickly I'll move to, there are parts of that I've left in the interest of time. Now, there's what is called, lastly on part 2, securitization finance. When you talk of a bond issue, for instance, you are talking of, one of the things to consider is the risk of the entire business. But the way the market has developed, so that finance is obtained cheaply. At times, a business that has various lines of businesses may compartmentalize one line of business and raise finance with it. That is the whole concept of securitization financing, right? So the party, say it is a Safaricom that is raising money, right? And it has other business, it has M-Pesa, it has airtime and all that. If M-Pesa is the most profitable, it can actually compartmentalize that part of business and raise finance with it. Now, what it will entail is that this compartmentalized part will be transferred to a third party called a special purpose vehicle, which is a new company that it creates, right? Very new in the market, and there are reasons for that, right? Then, it is this company that then approaches the market to raise finance through a bond issue. Securitization finance applies to listed companies. Why is it important? The whole idea behind it is to raise finance cheaply, so that you don't take the credit risk of the entire business. I have discussed the details of how that works under chapters 15 and 16. Part 3 of the book, which is the second last part, is on equity finance, which is capital markets law. In chapters 17, 18, 19, 20, and 21, I've discussed private placement mechanism. Not all companies are established enough to do a public offering. And so they may find some people that, particularly startups, that can invest in their equity. So I've discussed the modes. There's what is called a venture capital form of finance raising and the regulations that actually guide it. Private equity. Venture capital is for early stage startups. Private equity is more buyouts, and fairly established companies. And a new area of private placement called investment-based crowdfunding. They actually, you don't get equity in a company by that. They're actually platforms that will give you equity if you help them raise finance through their crowdfunding portal. So if, say, a private equity enters the market, the book discusses the structure of how a private equity firm is set up. Once the synergies have been built, at some point these investors will exit the market. This company will then be big. And how do they exit? They can exist through IPOs, they can exist through a trade sale, which is a new company, and a private equity firm, or they can sell to another equity firm. It's what is called a secondary buyout. Or they can saddle the company with more debts and get more money. Those are exit strategies. Now, quickly I'll move to IPOs. Yes, IPOs. And in IPOs, the only thing I can highlight now in the interest of time is the process itself. I've discussed the actual process of IPO. How does it always happen? Right from the time that someone approaches an investment bank, which are called the transaction advisors, to actually commence this process, right? And their roles. What does this transaction advisor do? What are the documents involved? There is what is called a red herring prospectus, which is set up initially without the actual price of the security. Then what is called a book running. Book running, if now you are testing the market to see the demand before you decide on price, and then before you prepare a final prospectus that you file. All right? So all that is contained in chapter 17 to 21. Now, there are corporate law issues to look out for when you are doing an IPO, and I'll highlight only one. One of them is the authority to allot. When you are raising money from the public, you first give right to the existing shareholders, right? Now, first, before we go to that, the authority to allot. You must have the authority as a board to actually allot the shares. You must have the authority. How do you get the authority? It can be stipulated in your articles or in a general meeting which can be called for that purpose to actually authorize you to allot. Now, regulation of capital, primary markets, secondary markets, and the liability questions, which are the last parts of part 3, discusses actually the process of how do we regulate trading in the primary markets. And the key thing here for me are the prospectus regulations, all right? The requirement that you must publish a prospectus, and what are some of the differentiation strategies, so that to an issuer and the investing public, there is there's some mitigation on the cost of issuing a prospectus. Secondary markets deals with 3 areas of regulation. Major holdings, if for instance there is a particular threshold which is achieved by a director, disclosure of that major holding. If there are director dealings, so that to avoid insider trading, that is also discussed in the book. And ad hoc disclosures, if for instance there's a big case that can affect the future of the business, like an oil, my friend Ataka is the expert here. If for instance there's an oil spillage, all right, that may impose a huge liability, to the business, you are under duty as the managers of the company to disclose, right? Now, last part of the book, as I conclude, deals with project finance. A project finance is a mode of finance that involves a partnership between the public and the private sector, where a public sector grants a license to a private entity to use the public utility and then recover its investment by operating the public utility. And the most common example we know is the expressway, for instance. How did we finance the expressway? How did we finance the SGR, right? I think there's a LAPSET project. The book has highlighted a few, that are out there, right? It's a cheap way through which government can achieve its economic growth, right? So the book actually discusses the players. How do we administer this? What is the role of the PPP committee? What is the role of, the directorate of PPP? If, for instance, the PPPs originated by a national government or by a county government, how do we go about it? How do we put it together? All that is discussed in chapter 25 of the book, all right? Then the procurement methods, after, of course, it starts with a feasibility study, then you go to procurement. Which are the procurement methods, which are for, right? Which are the contracts, right? The key one, which is set out under PPP Act, is called a project agreement, but there are others, right? Remember, the person, the project company, this so-called private party, may not necessarily be the one that does the construction. So you must have a construction agreement, right? There will be supply of raw materials. You need a supply agreement. Right now, if you pass through the expressway, the Mombasa route, There is a company there called Kenya Moja which did not do the construction. It's actually maintaining and operating the project, all right? So that's a contract on its own, now between the project company and the operator. If, for instance, assuming that the PPP involves generation of electricity, right? This electricity will be bought by somebody. That somebody, we call them the off-takers, right? So you need an off-taker agreement. All that is discussed in chapter 25 of the book. So, ladies and gentlemen, that is in summary what law of corporate finance in Kenya is all about. I thank you again for your time, and I now present the book.
Thank you, Matthew, for that summarized version of the book. For those who haven't got a copy of the book, please grab yourself a copy. You will get more of what Matthew has just shared. I'm going to invite my president, Law Society of Kenya. The only thing I will say about him is that he's the 50th president of the Law Society of Kenya, and he's an alumnus of Moi University. I must add that because I am one. Mr. President, Karibu.
Senior counsel and the, should we now call you author, and all the guests who are here this evening. You know, when Geoffrey said that it is evening, some of us who largely are guided by day and night to determine our activities, were wondering what he's talking about, because when we were growing up, the sun was the guide in terms of time. So it's either day or it's night. You know, when I was elected president, he also gave me a partner. And if I do not recognize her, there might be chaos in that household. So with tremendous humility, allow me to ask the Vice President of the Law Society to just come and asalamia wananchi. So Faith, please come out.
Senior counsel present, my president, Imende, Matthews, my good friend, all ladies and gentlemen present, good evening. I must say that for me today I came just to celebrate Matthews. Matthews and I had the privilege of being in the same KSL class, and we even, in our height of love of the law and the nation, what did we form together, Matthews? We formed an NGO together for the purpose of public interest litigation to offer back to members of the society. So that's how far back we've come with Matthews. And what I admire most about Matthews is his self-driven passion. So I love the fact that you first acknowledged God, because such diligence, hard work, and persistence, as much as you had great mentors, and we thank you for being great mentors, it also stems from God. the discipline and the ability to work hard. So this is encouraging for all of us. Encourage all of you to get a copy. And without a doubt, in line with the changes that are happening in our current society today, PPPs are going to feature greatly, particularly even in water projects. So I urge you, get your copy, read, and prepare yourself to practice good corporate law. And this being my area of passion and practice, I'm reading it with a critical mind. So we will have discussions about it, but today I'm here to just celebrate you. This is not any mean feat. I also teach at the university, so I'm sure I'll enrich what I share with my students at the University of Nairobi. Congratulations.
Thank you so much, Vice President. You know, Deborah, when you were making an introduction, you did mention that there are some important people. Then you, of course, did not recognize just how important Mr. Imende is. So at the risk that senior counsel might report to office on Monday and find out that his office has been locked by the managing director, but ladies and gentlemen, I think on my behalf and on behalf of the Law Society, I'm extremely delighted to be here this afternoon for this book launch. When Matthew invited me here, I did not expect the book to be 600 pages. And so when I got it but I had the opportunity to go through it, and I was extremely impressed by the kind of work. Of course, I've known him for a long time. I know him for being a diligent, dedicated, and enthusiastic advocate. And, you know, he's always rushing. You know, when you meet Matthews, he's always, you know, very fast, yeah? So I think I could understand how he got the time to do such a marvelous book, and I just want to really appreciate you for the work that you've done. I know that you have contributed significantly to the corpus of what we refer as indigenous law, and I want to encourage you to, you know, write more, and we'll always support as you undertake those ventures. Well, somebody, and unfortunately, I'm not very good at reading written speeches, so I'm just saying this because I see a camera is there and it's probably recording, so that these people who wrote me a speech would know that I've acknowledged the effort that they did. But also I take cognizance of the fact that time is really not on our side, so I would not want to take a lot of time to make my remarks, but I want to urge all of you here, especially the students, to make good use of this book. And you are lucky because the author is locally based. He's one person who I know is extremely approachable. We've spoken about the question of mentorship. You have to reach out. You have to reach out and say, I like what you have done. Can you be able to share your experiences with me. And I'm sure that as you undertake your studies, he can be a big inspiration to all of you, so that he can equip you with the necessary knowledge and skills to make you extremely marketable in the market that, because this is a new, sort of like what we would call an emerging area of practice. And so the old people like senior counsel in Aoga cannot be able to survive in this area. And I say that calling him old at the risk that he might demonetize the currency that I am holding, because he is extremely but that is to say that this is really an opportunity for the young members who are going through legal training right now to perhaps even specialize in a particular area of practice. And because you have Matthew's, I'm sure, is easily available, readily available. Like if he's not, you can report him to me, then we can deal with him in the manner in which we know how to deal with him. Do not report him to the wife, because if you do that now, he'll be finished. Yeah? Yeah, so I just want to encourage all of you to make use of this wonderful resource. And Matthew, once again, congratulations, and all the best, because the sky is the limit for you. Thank you so much, Deborah, for this opportunity.
Thank you, Mr. President. Now, the next speaker, who is our keynote speaker for today, because I mentioned that he's my mentor, it would be very embarrassing if I read his profile, because as a mentee, you're expected to know what you aspire and what your mentor does. So I'm just going to mention 3 things so that I publicly show where I aspire to be, and so that my mentor, Senior Counsel, Mr. Mohamed Nyaoga, can hold my hand and make sure that I get to that place. He's the chairman of the Central Bank of Kenya, that is 1. 2, he's a senior counsel and managing partner, senior partner at Mohamed Migai Advocates. And finally, he's a chair of the panel of experts of IMF. Mr. Nyaoga, welcome to the podium.
Good afternoon. I will not say evening, like my boss here, Mr. Imende, because we can see the light out there, so it's not evening yet. Matthew, thank you very much for bringing us here today. Mr. President, thank you for being here today. Vice President, the better 3/4 of Matthew is here today. I think she was a big inspiration to the writing of this book. I've always known Matthew to be resilient, but I'm sure most of you will agree with me that Matthew is a very humble giant. He's a gentle giant. Even his demeanor is that of a gentleman. When you see him, you don't see the demeanor of an aggressive person. You know, there are people you see, if you meet them, you think they're about to beat you up. But this gentleman is very humble. But even when he was at the law firm, very resilient. He thinks very carefully. Whenever you gave him assignments, he executed them with precision. To write a book is not an easy thing. And I have never known anybody who has been killed by reading or by writing. If you know any, please tell me, because nobody ever gets sick from reading or writing. But unfortunately, not many of us take time to read or even to write. I keep saying that learning is from womb to tomb. You learn from the day you are born until the day you die. The day you stop learning, you die. So I don't know how many of us now here are dead, though we are physically here. But that inquiry, we shall hold it at the end of this meeting today. Ladies and gentlemen, I'm pleased to be here today. I want to stick to the script for this very important book launch. I'm grateful for the invite and applaud the author, Matthew, for this landmark occasion. This is a very technical area, and I'm sure most of us were floating in certain areas that he was touching on, but if you spend some time, I'm sure you'll enjoy the content of this book. Finance, both corporate and public, is at the heart of the discourse, not just in Kenya, but across the world. Significant financial resources are required for both public and private investments. Additionally, public and corporate finance must work together to meet the growing societal needs for infrastructure, health, education, and other social services. Governments on their own cannot fund these important needs for their citizens. With the growing prominence of corporate finance comes the need for regulation. The regulatory framework must balance and protect the interests of various stakeholders, including the public, investors, and shareholders. The launch of this book today on corporate finance in Kenya is therefore a useful addition to the body of knowledge on this topical subject. As we celebrate the launch of the book, let us reflect briefly on the global, regional, and national context that we are currently in. Three broad themes define this conjecture. First, the global economy is reeling from the high cost of living exacerbated by high fuel, food, and commodity prices. This has been worsened by geopolitical conflicts in Europe and closer home on the African continent. The harsh economic conditions have affected advanced, developing, and emerging economies, even as the world recovers from the COVID pandemic. But there are glimmers of light as we turn to 2023. The reopening of China's economy following the pandemic, early indications of normalization of global financial markets, and lower energy prices are indicators that the worst may be behind us. Second, technology and innovations continue to evolve at a rapid pace. These developments have created opportunities to recreate society, governments, and corporations. This has powered growth of anytime, anywhere services in diverse sectors, including education, financial services, health, and retail. Ladies and gentlemen, on the converse, these developments have generated prominent risks inter alia cybersecurity and data privacy. The transnational reach of big techs has only served to amplify these risks, particularly data privacy. Recently, retail investors in advanced economies have borne the brunt of collapse of cryptocurrency entities such as FTX that had grown in prominence in recent years. As you know, these are faceless currencies from faceless individuals. Third, climate change continues to wreak havoc globally, manifested in snow, storms, and floods in USA, floods in Pakistan and Nigeria, and the prolonged drought in the Horn of Africa. You've seen what happened in Turkey and Syria the other day. In a nutshell, climate change is now evident in advanced economies as well as emerging and developing economies. And we can see that. We can see drought in our country. Against this backdrop, corporate governance and leadership are critical to navigate these challenges. Let me pause there. What we have seen in our societies are leaders who are eager to carry or to take the bag of leadership, not the baggage of leadership. What do I mean by that? When you take the bag of leadership, you are actually taking the position. But the baggage is what you do with the position. You can apply for the position of a CEO of a company, and because you are not focusing on what to do with that position, you get in there and then you ask people, I'm the CEO, what does a CEO do here? We are looking for leaders who espouse the 3 I's of leadership. That is impact, inspire, and influence, but with integrity, which is cross-cutting. Ladies and gentlemen, we have had organizational failure. And you recall the 2007 financial crisis. Organizations fall on their governance and leadership. In the financial sector, corporate governance lapses have been at the heart of failures of financial institutions, including the global financial crisis of 2007, receiverships of banks in Kenya, 2015, 16, and 2022 shocks in the global crypto assets markets. I will point 3 broad critical governance and leadership considerations towards effectiveness of finance in society. First, finance must meet the needs of the people of our society. Finance should not be disconnected from the needs of society. The public anger, not just in Kenya, but globally towards the financial sector, has been fueled by the perception that the sector does not work for and with the people. This has been amplified by the public perception that the financial institutions are more interested in profits made on the back of the efforts of citizens who bear high interest rates and charges. Boards and management must keep in touch with the pulse of their customers, ensuring that they provide relevant and affordable financial services and products. Second, ethical culture is imperative in the provision of financial services. Market misconduct, including misleading customers, publishing inaccurate financial statements, and outright fraud has led to the downfall of financial institutions globally. Boards have the cardinal duty of setting the tone from the top, which translates to the tone within, for responsible conduct across the institution. Financial institutions must have appropriate policies approved and overseen by the board that embed an ethical culture in the institution. Sound institutions must have in place good policies, systems, processes, and procedures that drive the business. Third, it is imperative that financial institutions take a long-term view. Often in the corporate world, boards and management get caught up in the culture of quarterly financial performance. The orchestrating driver of common performance becomes short-term profitability indicators to showcase in quarterly investor calls and briefings. To make an impact on Africa's socio-economic and transformation, the private sector must take a long-term view. Significant investments need to be made by the public and private sectors to meet Africa's development needs and build resilience to climate change. In conclusion, ladies and gentlemen, we can discuss the merits and demerits of various regulatory architectures for corporate finance, as has been done by Matthew here today. However, the quality of governance and leadership is what determines whether the ultimate purpose of finance, of working for and with citizens and business, will be achieved. I once again congratulate the author and organizers of this event and look forward to our discourse today. Today is just the beginning of this conversation. I'm sure we have several takeaways and several nuggets from listening to Matthew today. We need to reflect on this in our professional and personal capacities. Thank you very much.
Thank you so much, Senior Counsel Mohamed Nyauga. We're now going to have a plenary session, a very brief plenary session because of time. I would like to know from the audience, please raise your hand if you have a question. That means that the sessions must have been extremely, there's nothing left out. You have no questions. Yes, gentleman in blue, if somebody could kindly help me rove the mic. So I'll take 3 questions. Sorry. And just before he asks his question, I have a question for Senior Counsel Mr. Nyauga, just picking up from the conversation that we've just had on corporate governance and finance. You highlighted that there are various challenges with financial institutions, but I'd like you to take it from the angle of, we're talking about financing for corporates. Kindly tell us your view from a regulatory as well as corporate governance perspective with regards to companies who seek financing and who seek, who want to be funded. What is the central bank's position on that, and how do you tie that into what you've just talked about with regards to corporate governance? Because yes, you regulate the financial institutions, but the financial institutions serve the corporate. So what is your take on that, and what would you tell us as companies who are coming, if somebody is coming to seek a facility, what would you be keen on?
Thank you very much. I don't know whether I answer from here. Let me face the audience. As I mentioned in my remarks, corporate governance is at the very center and in driving the business of any institution. For you to go out there and seek financing, whether you're a small corporate, a big corporate, you must be governance ready. If you look at our prudential guidelines that we have issued for the banking sector, we specify that the boards that oversight these institutions must have certain credentials. We vet these board members. We look at the governance structures in these institutions. And remember that the oversight boards are not the managers of the businesses. In governance terms, we say, for the boards, noses in, fingers out. But the boards put in place senior management. They recruit the CEOs, they recruit senior managers of those institutions. Those are the people that drive those institutions. But within those institutions, within the board, we have board committees. This could be in credit, there could be risk, there could be human resources. But those committees operate under specific terms of reference. At the very center, or the manner in which those committees operate, or even the board, is risk. Because when you advance credit to corporates, you must weigh your risk. You must analyze to ascertain whether those entities you are advancing money to are able to pay. Otherwise, you are going to have huge non-performing loans within the institution. And that's why, if you look at some of the institutions in Kenya that went under in 2015, 2016, they went under because non-performing loans, but fraud and poor corporate governance in those institutions. You are aware that there are people who get into boards without really understanding where their role is. And the issue of training is very, very, very critical. I remember somebody calling me one day. He wanted to join some board where I was a director. So he asked me, I've been asked to join this board. What is there to eat? So I said to him, whenever we come for meetings, we are given sausages and mandazi and tea. He said, I don't mean that. The point I'm making here, there are people who come into boards without appreciating what is required of them. They're looking at the allowances that they collect from those institutions. That also drives corruption, it drives fraud. If the board is not functional, we always say the fish rots from the head. And if you have a poor governance culture within an institution which is not effective, which is not a respecter of the best interests of that entity will collapse. And at the end of the day, consumers will suffer because their hard-earned money will be lost. Thank you.
Thank you.
Thank you very much, Deborah. My name is Moses Owor. I'm an advocate, work at Ombok and Owor Advocates, LLP. I've looked at this book and I'm very, very impressed. I think Matthews deserve all the accolades he's received and all our appreciation and admiration. It's a very, very good book. I think one of its kind in our jurisdiction on this subject. And thank you, Matthew, for very in-depth discussion of these topics, which I believe is new and becoming a dynamic and growing area of practice. My question, and not really a question but a comment, relates to two things. One is, how do we use such a book to develop discussions on consumer protection? Because it's an emerging area, very new products that you've discussed in a very in-depth manner. And one of the things that I believe this is a junction with what Senior Counsel Mohammed has spoken about, that the risks in both corporate and public finance internationally is as the products emerge, there is a new impetus towards consumer protection. So how do we use this discussion to develop work around that area? Secondly, how do we use such a book to also develop discussion around other emerging areas like venture capital, private equity, or we just, because I think you've discussed the products themselves, both equity and debt in depth. Do we just use this book as discussing corporate finance and therefore venture capital and private equity and other creative ways of raising capital, then fall to be discussed under the specific subject of the products that you have very well elaborated in the book and on the financial regulation side? And in the financial regulation, what I've seen, you've done quite an excellent job. I don't know to what extent, how do we evolve it to regional integration and the dynamics that come with that? Thank you very much.
Because that is our Kili, he asked 3-in-1 questions. So I'll allow Matthew to take those questions, and then we'll have the lady, you ask your question next, and then the gentleman at the back.
Thank you, Councillor Owuor, for the compliments. One of the key drivers in writing this book actually speaks to your first question on consumer protection. And I looked at consumers to include investors who actually invest. In my discussion on capital markets, there is a large part that I've dedicated to how can we, for instance, reform our civil procedures to be more access to justice friendly. If you look at the greatest impediment, and perhaps the real reason why we don't even have many cases on securities fraud litigation, is because of, first, the very high threshold that is imposed upon these potential litigants that they have to meet for first even just to have audience with the court, the issue of standing, right? And even if they have that, the limited number they can sue. The book, for instance, identify only an issue. But in more developed systems, they have been more liberal. You find that they've brought in even gatekeepers. For instance, if you have an underwriter, who knows very well that you are being misled in this particular securities issue. You, as an investor, eventually, you should be allowed to sue that particular underwriter because they had a duty to disclose to you in the prospectus that the information they are giving you are incomplete. Or even if you look auditors, key players in the process of the issue. So yes, we need to think, and I've attempted to think through from that perspective, that we need to reform our civil procedure so that they enhance participation of the public. I like, for instance, what they've done in the US. There's what they call an opt-out procedure. If, for instance, you are defrauded in a securities issue and you are a large, for instance, investors can be in their hundreds of thousands, some in the villages. All that it requires is that one person takes out a suit who may be an informed lawyer in the city. And then everyone that bought a security under that particular issue, automatically they become plaintiffs and they're entitled to redress. But now we have a rigid system under our civil procedure laws, which require that you obtain authority. For instance, you have to obtain authority for you to bring a class action. So I think we need to really even petition our petitioner in that regard, so that we can create more space on access to justice. Regarding some of these products that are emerging, the book actually sets the agenda for now more deliberations, right? Because strictly speaking, we only have one regulation on venture capital, right? And it only applies if there's a part of that capital that is drawn from the public. And you find that some of these private placements, they don't draw money from the public, right? So we need to think through a product so that people don't go through processes of, and some of the experiences that we've had with some of the issues that have been in the news, where, you know, these venture capitalists, they come, they make the money, they disappear, but you have very limited recourse against them. So the book only sets that discussion for greater reform. Regarding regional integration, at some point I've tried to look at what is called a regulatory arbitrage, where I took a very deliberate step to look at you know, our corporate law, particularly on regulation of the capital, and I've done an audit with what is obtaining in Tanzania, what is obtaining in Rwanda. I think it's Tanzania, Rwanda, and Uganda, right? And the whole idea was to try and assess, is there first a possibility that we can advise our policy makers that we risk losing some investors if our business environment is not friendly. I believe that then sets the stage of harmonizing our laws to even now go beyond the East African region. So that is my comment to you, Council.
Good evening. My name is Patricia Muma. I'm an advocate of the High Court of Kenya, and I am a student of corporate finance. First of all, I think from a student's perspective, I just want to thank Mr. Okoth for coming up with this brilliant publication. I think it's much needed, as Mr. Imende had alluded to in his speech. You've localized concepts that we are learning from a very foreign or international jurisdictions. You've brought it home. I've just looked through some of the content, and I can see you're making reference to Kenyan law. You're making reference to Kenyan cases, examples that are local to actually marry the very technical concepts that this particular area involves. Now, I think firstly, I just want to thank you very much. You've answered part of one of my questions, which was in relation to integration, because of, I'm looking at the AFTA, which is the African Continental Free Area Trade Agreement, which is a new concept, and it's trying to harmonize the whole of the African continent in terms of trade. So my question was, how does now Kenyan legal financial framework marry with other jurisdictions, and whether you've addressed that? I think you've alluded to that, and I think once we read, we can have more discourse. But my second question was on the concept of sustainable finance, and whether, basically, we've heard of the green bonds, the blue bonds. It's an emerging area, and I just wanted to find out from now your expert view, whether Kenya is hoping that we are going to be a regional leader. Are we ready to take up these financial facilities or to attract investors, using the book and just from your understanding of the sector, and whether that has been addressed in your book.
Thank you, Councillor Muma. One of the issues that really I was keen to highlight is on codes of corporate governance, that some of these entities that set out to raise finance have to comply with. We call it ethical finance. So I appreciated that there are divided debates, whether indeed there are things that should be regulated strictly. But I think the approach that the Kenyan regulators have taken is apply or explain, right? So that apply or explain principle requires that you must really justify why you are not engaging in certain prescribed ethical behaviors, both from the structure of your board, in terms of your investment, environmental protection, and all that. So yes, the book has a portion where it gives a highlight of that, and perhaps through you, Deborah, I can also perhaps allow my senior to comment on that. Yeah. Corporate governance in finance. All right, thank you. Is it clear enough? All right, thanks.
Good evening. My name is Blaise Kwasi. I'm a trainee advocate, and my question is on one of the emerging trends currently on SPACs, special acquisition companies. Maybe you can comment on the situation of SPACs in Kenya and the regulation regarding SPACs. And going forward, actually I think the last IPO that was launched in Kenya was about 8 years ago. And going forward, will we see companies going public through SPACs? And might you also have commented about SPACs in your book? I haven't had a chance of looking at it yet. Thank you.
Good evening, everyone. Protocols observed. My name is Mercy Kamau. I'm also an advocate of the High Court of Kenya. In the area of corporate practice, I happen also to be a director in a bank for a long time. So for me, this is indeed very timely. Most importantly, actually, I came here courtesy of my bishop, Bishop Mutungi, and I happen to also be a reverend in the Anglican Church of Kenya. Now, I'm a key player in church finances, and I'm sure my bishop, that's why probably he invited me today, so that we can see what this book has to offer. I'm imagining that we will encourage you and inspire you in your season 2 to look at church and finances. Recently, you were all watched when Majestic City was launched. It is a project authored by a church, Deliverance Church. I happen to have quite a number of churches as my clients, and they have huge ambitions. But corporate governance in churches and its finances is a very gray area at the moment. I admire the Catholics, the Protestants, ACK, PCA. Maybe out of history, they've developed corporate structures. But we have our brethren, the evangelicals. And the evangelicals have been studied. On Monday morning, they bank, and I'm sure the chairman of the Central Bank of Kenya will support this. They bank billions on Monday morning. They buy land in huge droves. They have their major social transformational tools. They are now very much interested in affordable housing. and building malls and so on, there is serious project financing knowledge needed in the religious sector. So mine is perhaps to ask you whether you, in your chapter, which I have keenly read through on project financing, you need to incorporate faith-based organization and project financing. And maybe my senior, who I admire very much, has also shaped my life, Senior Muhammad, can also make a round table for churches and finances and how to integrate them with CBK, what are all these requirements, financial regulations. So over to you for that.
Thank you so much. I'll just allow Matthew and Senior Counsel to react to that, and then Matthew can also answer the other question.
Thank you, Counsel. I'll start with your question. SPACs are dedicated funds for investment in particularly startups that have high growth potentials. And in the chapter where I was discussing private placements, largely they always invest in either as venture capitalists. A SPAC is just a fund. But now where it is applied, the product itself is either venture capital or it can be a private equity, right? So yes, the book highlights that and also appreciates the growth, particularly of the private equity market. Because as you rightly pointed out, people are running away from listing in the IPOs. And why is that? Because of these rigid disclosure obligations. So it is easier to raise finance by an individual investor that will come in, create synergies, and then once they make profit, they can themselves exit, the particular entity. So yes, that is highlighted. Before I usher in my, okay, can I usher in? Right, now on churches, Reverend, thank you so much for observing. And it's good you've raised it because I'm also a faith-based person. I have the privilege to serve in a position in Anglican Church. And so I am privy to some little information. We are not very poor, right? And so the church can take up some of these opportunities. Project financing is just a private citizen looking at some of the opportunities that are available in the public sector that they can partner with the state over. And there's a procedure which I've discussed in my book. If you look at it, it's called privately initiated proposals. At times you don't even wait for the government to tell you that, for instance, we want to do PPPs for water projects. You can yourself identify a sector where you think, for instance, in a region where the church operates, that this particular project we want to partner with the government or even a county government, forget even about national, to provide services with. And then the county government, for instance, can give you a project to build schools, to build hostels, for instance, as a church. You are a private entity that is partnering with a county government. So yeah, that's an area which is good you've raised it in the presence of our Lord Bishop. Perhaps they will consider it at higher levels. Thank you so much.
Reverend Mercy, I didn't know that you're now a reverend. Reverend Counsel Mercy. Okay, you raised very fundamental issues. You see, these churches, registered societies, etc., etc., they file their own returns. Some of them run SACCOs, and these SACCOs are regulated by SASRA. Yeah, but again, most of these churches, no one size fits all. You find one church follows this structure, the other church that structure. But at the end of the day, it is really the internal governance structures that bring about accountability to the members. I know there are churches that, and I don't wish to say this, today is Friday or it's not Saturday or Sunday. There are churches that belong to individuals. That's the truth of the matter. And they are the treasurers, they are the chairmen, they are the directors, they are everything. So it's a very delicate area, and we don't regulate them. And if you are dealing with your bankers obviously there is banker-customer relationship where you have to perhaps agree on how you conduct your bankings. On Monday, you said billions. I don't know whether there's a taxman here, but the taxman must be listening very carefully about that. You didn't name the charges. The tax, of course. So these are things that we can discuss separately, especially in terms of corporate governance, because there are certain challenges. There are charges that are structured, they have their own constitutions, they have a particular regimented way of doing things, and that's what it is. That's why there's no one size fits all.
Thank you all for that very engaging session. You have a burning question. I see one hand up. I was going to wind up the plenary session. You have a burning question? As we take that question, I'll kindly request one of our students, Cecilia, kindly approach the podium. She will give the vote of thanks. Cecilia?
Thank you so much. I'm Agesa Leonard. I'm 18 months shy from being an advocate of the High Court of Kenya. And not really binding questions, but questions of interest. I'm just interested to know from council, other than those of us who may not have the opportunity to maybe get a copy today, are there any specific places where we can get a copy of the book? Lastly, other than being humble and shy as has been described, I can see passion in your presentation. I'm just interested to know what was the driving force for you to venture into the corporate world, and why just corporate? Thank you.
Thank you, Council. I informed my president, Mr. Theory, of my key driver, the real reason why I wrote this book. As a practitioner in Kenya, I get really worried as the number of lawyers increase. And it really falls on us as lawyers to think long term, how we can expand practice opportunities. That is how we will survive. We appreciate our predecessors for doing their bit in really entrenching certain areas of law that have enabled us to also carry this title, lawyers. But as time goes, the numbers increase. So the real drive behind it is to do my fair share in trying to initiate a conversation on what are other areas that we can venture in. I was sharing with my mentor just before the meeting started. If you look at securities fraud litigation, that is the mainstay of almost 40% of the firms in the US. What are we doing about securities fraud litigation in Kenya? It's almost nil. A lot of the matters just end up being settled at the CMA and the Capital Markets Tribunal. There is no much involvement of the public. So we need to initiate this conversation so that when we have this chance, and I encourage all of us in your areas of passion, expand them. Now the second question is commercial. I'm not sure whether I'm the right person to, and I kindly urge you, Council, pass by the desk there. You will get a full brief on where to get this book. Currently, we are still in the process of partnering with other distribution channels. So there's an email address that will be given where you can just, once you send the email address, you will be assisted on how to be given a copy. As you can see, today we carried almost 100 copies. They're available. Thank you so much.
The president of the LSK, the vice president, the keynote speaker, the leadership of the school, Madam Anne, senior advocates, fellow trainee advocates, greetings. So I would like to take this opportunity to thank Mr. Matthews for taking the opportunity, or rather considering to hold your book launch in our school. We are really honored. I want to thank you also for taking the opportunity to write a book on such a very as one of the speakers alluded earlier, one of the very complicated areas of law. As my good lecturer in commercial transactions likes to say, every rich lawyer in town practices commercial transactions. So it is my belief, and also I hope that my fellow students who are now planning to become one of the rich lawyers in town, that you will interact with that book. I also hope that Madam Anne, you will make a very big order on behalf of us so that we can interact with the same book. And Mr. Matthews, you could also be kind enough to donate some of the pieces. That's an expensive joke anyway. So I would like to thank the audience for your patience. I understand that it is a Friday, time is far much spent. I wish you a happy weekend, and I mean that.
Just before I call the Right Reverend to close with a word of prayer, we have a ceremony. Remember, this was a book launch. It wasn't a lecture. I'm sorry if you felt like it was a lecture, but it was actually a book launch. So the most important thing that brought us here is the launch, and we're going to have a small ceremony here. I just request whoever is handling that to come forth. As they come forth, Agnes, Matthew, and team, for this symbolic activity, you might be wondering, who am I? I am not a TV presenter, much as I do that on the side. I can see my president looking at me and wondering whether that is allowed as a member of the Law Society. I am a member of the Law Society of Kenya, which means I'm an advocate of the High Court of Kenya. My name is Deborah Juang. I'm also a company secretary practicing in the field of finance. And this could not have spent my day better than being here to be part of a launch of a book that handles and addresses things which I have experienced in my area of practice, which I have wondered about and not found answers, which I have, as you said, found foreign answers. So this is really timely, and I thank you for your patience and your participation.
Ladies and gentlemen, please join me in officially launching this book, The Law of Corporate Finance in Kenya by Matthews Okoth. Thank you.
Thank you. And now we can stand and we celebrate God's faithfulness and goodness for what he has done this afternoon. Let us give thanks. Father, in Jesus' name, we want to thank you for the many, many blessings that we receive each and every day. And in particular this afternoon, where we are celebrating the launch of a new book by Matthew Okoth. We want to pray that God, the knowledge that has been gathered and put in this book will be beneficial to the readers, and that God will use the knowledge to transform the communities and even business people, corporate sectors, and even public sectors. We pray that God, it will be used for honor and the glory of your name, this knowledge. Thank you, Lord, for our chief guest. Thank you for our author. Thank you, Lord, for all that have attended this ceremony. I now commit them to you, that they may find favor. Even as they go, may your peace be with us and bind us together. We bless our country, Kenya, where we find peace, and that we can continue to carry on our daily activities and our businesses. We pray for the government that, Lord, you continue to inspire them to be able to lead the citizens of this country with your peace. And we pray that, God, you may continue to honor your people as they turn to you and they seek your face. May you provide, may you continue to direct, and especially for those who are suffering in famine, in drought, and where, Lord, so many challenges of family issues are being faced. We pray that, God, you continue to sustain your people. And now, mighty God, we bless this congregation, and I pray that, Lord, bless each one of us as we now part. In the name of God the Father, Son, and the Holy Spirit.